Hey folks, Dave Ceruolo, real estate probate and elder law attorney. In this video, we're going to talk about what happens when a loved one passes away and they have a piece of real estate in their name individually. Now, if you're watching YouTube, please be sure to click subscribe in the lower right-hand corner. If you're watching Facebook, please be sure to like my video. Stay tuned. What happens in Massachusetts if a loved one passes away with assets in their name individually? Well, what happens at that point, folks, is you have to approach the probate court, whether there's a will or not, and file a petition with the court. Now, under the Uniform Probate Code, which is relatively new in Massachusetts, you can file one of two ways. If all of the heirs are getting along, you can file the petition informally. With an informal petition, a magistrate and not a judge is assigned to the case. And a lot of the decisions that are made by the court can be made administratively with no hearings necessary, saving the estate money. Now, if the heirs are not getting along, there's a second way that a petition can be filed, and that's formally. And with a formal petition, a citation is issued by the court, a judge is assigned to the case, and there may be hearings down the road. And what happens at that point is the judge makes the decisions on those matters. Dave Ceruolo, CeruoloLaw.com. So what does it mean to pass away testate? Well, folks, when you pass away testate or a person passes away testate, that means that they pass away with a will. Now, that's as opposed to intestate, which means they die without a will. So watch my prior videos on the laws of intestacy because those will apply at that point. Now, the will itself is going to appoint what we call a personal representative. We used to call that an executor of the estate. The personal representative is going to handle the estate and pay the debts of the estate. Also, the will is going to designate heirs that are going to receive the assets that flow through the will. Now, that will need to be introduced to the court. There's one of two ways to introduce a will to the court. Now, watch my prior videos on that, but you can introduce a will formally or informally. Now, the assets themselves have to be held in the individual's name individually. They can't be held jointly. They can't be held in a trust or any type of investment. And so those assets will flow through the will. Dave Ceruolo, CeruoloLaw.com. So what is a license to sell real estate? Well, folks, a license to sell real estate is a special permission that's granted by the court, a probate court, to a personal representative, used to be called an executor, of the estate, which would allow that person, that personal representative, to sell a piece of real estate. Now, why would a personal representative need to petition a court for a license to sell? Well, if the loved one, let's say we call him the loved one, the person who passed away, didn't have a will, they died intestate, the personal representative will need a special permission from the court to sell any real estate that's contained inside the loved one's estate. That would be the first instance. Second instance would be, let's say the loved one's will was drafted, but it was poorly drafted and it didn't have a power of sale, a power to sell real estate contained inside the will. The personal representative will then need to petition the court for a license to sell that real estate. Without that license, the property can't be properly sold. Dave Ceruolo, CeruoloLaw.com.